Bonjour à tous les participants. Good afternoon, good evening, good day, depending where you stay. Buenos días a todos los participantes y participantes. Welcome to this expert exchange on the role of labor inspection and fair recruitment. My name is Myriam Boudra. I will facilitate this webinar. I'm working at the International Training Center, and it's my pleasure today to welcome all of you in this event. We are very happy to organize this event with the Labor Migration Branch and the Labor Inspection Branch of the ILO, bringing together a wide range of expertise from within the house. As you all know, exploitation of migrant workers is unfortunately very common at the workplace, but it's even often start much before the worker even enters at the workplace. It's even sometimes happening at the recruitment stage. So monitoring compliance with relevant law at that stage is particularly critical, and yet often very complicated to organize. I would like to give the floor to Mr. Joaquim Pinado Nunes, who is the Chief of the Labor Administration Branch, Labor Inspection and Occupational Safety and Health Branch at the ILO, and who will officially open the webinars together with Maria Galotti, who is the Labor Migration Specialist at Migrant Branch, and who is also oversee the whole fair recruitment portfolio, if I might say, of the ILO. Joaquim, the floor is yours.
Thank you so much, Miriam. And first of all, let me welcome all participants to this technical exchange on the role of labor inspection in relation to fair recruitment for migrant workers. Let me also start by highlight that this event is a joint collaboration between different branches of the ILO. As you mentioned, LabAdminos, which is the branch that deals with labor inspection, and the branch of the ILO that leads with migrant work, which is called Migrant, but also with the International Training Center that we have in Torino. So this is a webinar that combines a wide set of expertise to address this cross-cutting issue. And I'm very happy to know that we have more than 35 countries that enrolled for the webinar. So I think that we'll have, a very interesting exchange of ideas, knowledge and practices throughout this event. This seminar, I should also say that it takes place within the framework of the Fair Recruitment Initiative Knowledge Hub, which is a platform to share research and knowledge in the area of recruitment. So the tripartite members of the advisory committee of the Fair Recruitment Initiative met early this year and identified precisely the area of labor inspection and inspection of recruitment abuses as one that indeed deserves priority attention. For some of you, and you'll hear, to speak about these guidelines throughout the meeting, the general principles and operation guidelines for fair recruitment, which constitute, I would say, the most up-to-date negotiated international guidance on fair recruitment, clearly recognizes the important role, the critical role that labor inspectorates have in terms of ensuring the effective enforcement of recruitment regulations. They call for governments, as a matter of fact, to work to ensure that there is an effective and sufficiently resourced labor inspectorate, and that the labor inspectorate and labor inspectors are empowered and trained exactly to investigate and intervene at all the different stages of the recruitment process of all workers in all enterprises, in all sectors, and also, again, important to stress this, to monitor and to evaluate the operations of all labor recruiters. I mentioned also, a reference also to the recently adopted ILO guidelines on general principles of labor inspection, adopted by the governing body of the ILO this past month of March, that also highlight the universal scope of the labor inspection systems, which should cover all workers, all workplaces, but also all that falls under the remit of labor and employment legislation, where of course all that deals with recruitment needs to be considered. So just a couple of words also on this webinar. So the webinar, this event, is part of a process that we started about a year ago with the first technical seminar, where a number of you were there already, and where a number of you already shared quite interesting practices and emerging approaches on this area of inspection of recruitment and potential violations, and how to address these violations through labor inspection and other enforcement authorities. So since this initial meeting, we have conducted a good number of interviews with many labor inspectorates to deepen our understanding on existing good practices, but also on challenges that inspectorates have in practice to address recruitment-related abuses. And on this basis, we have finalized a technical note that will be presented here today to you, and that will constitute, in a way, the basis for our discussion throughout the meeting that we are having here today. So as we continue our technical exchange and our learning process, we are happy to have here with us a quite expanded number of lab inspectorates and partners to discuss also what would be the way forward for the ILO in terms of any knowledge gaps, experience sharing that the ILO could facilitate, between different ILO member states, between lab inspectorates, between enforcement agencies, and I also say, of course, between national authorities and the social partners. So we have invited some expert speakers to provide us with some highlights on what is being done in their countries. And on this meeting, we also hope to hear from all of you on your experiences. So we would like to make of this webinar an event as interactive as possible. So in spite of time constraints and online limitations, we look forward to receiving your inputs and to have an interesting and lively debate on this very important subject matter. So I wish us all a very successful meeting. And now I'm giving the floor to my colleague Maria Galotti that will proceed. Thank you.
Thank you. Thank you very much, Joaquin. Buenos días a todo el mundo. Bonjour tout le monde. Bonsoir. I'm very happy to be here. Thank you, Joaquin. It's indeed a pleasure to be here together with our library inspection experts and also the colleagues from the training center of Turin. I think this is an example on how we can bring together a multidisciplinary approach to this very important subject. And I just, not to take away time from the real experts who are here today with us, I just wanted to point at the fact that today we find ourselves with a whole array of international labor standards and international instruments and guidelines that give us indeed guidelines on how to improve recruitment practices. But we also need to go deeper and more granular in our analysis, more practical, and hence why this is so important for us to be here with such a number of experts that have, really work on implementing these guidelines on the ground. So we want to hear from you all and hear on how you face some of the challenges that we have identified, and we very much look forward to hearing from all of you. So I will stop here in order to make sure that we have enough time for really having a fruitful discussion. And thank you very much again, Joaquin, for this collaboration.
Thank you very much, Maria. And indeed, I think it's very important to highlight that this meeting is very much to hear about the expertise and the experience as well of the different participants who joined the meeting from, as you rightly mentioned, Joaquin, more than 30 different countries. So we see that we already have 102 participants, including the panelists. But I think it's very promising as well for exchanging. So please make sure to raise your hand if you want to take the floor at one point, to use the chat box if you want to share some comments with the panelists or with the other expert present. And I just want, sorry, I forgot to say that at the very beginning, their interpretation is available, as you may have seen, in French and English and in Spanish. You just need to click on the interpretation logo and just to pick the language you want to follow the event. Without further ado, let me give the floor to the expert who has wrote and he's written and finalizing an important paper looking at different cases that he will present during this first part of the webinar, and then we will have the chance as well to hear from some of the representative of the different case. Mr. Hans van der Gleen, who is a senior consultant on international labor rights, we have the chance to have you with us today. Thank you very much, Hans, and without further ado, I give you the floor.
Thank you, Miriam. Let me open a PowerPoint, hopefully to help us communicate in the different languages about the paper I'm going to present. I'd like to thank you all for giving me the opportunity to talk to you all. The paper I'm going to present is based on a desk review of literature and communications with key informants. I would like to start by framing the paper. In 2019, there were about 169 million international migrant workers. Many of these workers use the services of private recruitment agencies, and these include sub-agents, placement agencies, and labor supply companies. These private recruiters, they may play a very useful role to match migrant workers with employers in countries of destination, especially in a context where rules and regulations are complicated and where they differ from country to country. The paper and this webinar look into possibilities to monitor the operations of these recruiters directly and afterwards through workplace monitoring. I'd like to say up front that not all recruitment is bad. Recruitment of migrant workers can and often does contribute to decent work, as we see on the left side of this visual. However, it can also be abusive and lead to exploitation in its worst forms, in forms of trafficking or forced labor on the right side of the slide. Abusive recruitment practices may include deception, contract substitution, worker-paid recruitment, and inflated recruitment costs and debt. I'd like to point out here that for higher skilled migrant workers, the recruitment costs, they tend to be paid by the employer. However, for lower skilled migrant workers, the recruitment costs are often paid by the migrant workers themselves, despite regulations in a number of countries against this. Recruitment abuse of migrant workers impacts the world in many ways. It affects the lives of millions of migrant workers and also their families. ILO estimates that workers pay between 5 to 10 billion US dollars in illegal recruitment fees per year. And many of these workers, of course, are migrant workers. Excessive recruitment fees paid by migrant workers can result in debt bondage and situations of forced labor. And this is an impediment for countries to achieve labor-related targets under the Sustainable Development Goals that all countries in the world have committed themselves to. Under the fundamental principles and rights at work, ILO member states have an obligation to stop forced labor, including forced labor that results from recruitment abuse. So continued recruitment abuse compromises the obligations of those member states of the ILO. Allowing recruitment abuse to continue also sustains a multi-billion-dollar business that is flawed. Impunity of unscrupulous recruiters prevents a level playing field for decent actors. Now, labor inspectors may play a role in monitoring for fair recruitment, and this possible role is clear in recent international labor standards and also policy instruments that Joachim in his opening remarks already referred to. The highlights of these are listed on this particular slide, in particular the bits in green. Now, these international labor standards and policy instruments, they point quite clearly at the importance of regulating or licensing recruitment services, and secondly, the enforcement through labor inspectors or other competent public authorities. However, the role and mandate of labor inspectors in monitoring of recruitment of migrant workers is less obvious in many national practices. The mandate depends on national regulations pertaining to labor migration, forced labor, trafficking, and unfair recruitment. Labor inspectors, they tend to operate only in sectors of the economy that are covered by the labor law. However, migrant workers often work in sectors that are not covered by the labor law. And here I'm thinking of, for instance, domestic work and often work in agriculture. The mandates of labor inspectors with regards to monitoring of recruitment also differ depending upon whether we are dealing with a country of origin or whether we're dealing with a country of destination of migrant workers. And countries may differ in terms of how recruitment of migrant workers is organized and whether or not public employment services also play a role in addition to these private recruitment agencies. That is all in terms of framing the paper. In part 2, the paper offers a listing of challenges, and in part 3, it comes with a set of recommendations. And as these challenges and recommendations are an almost mirror image of each other, and as we have time constraints, I will focus in the remainder on a set of recommendations. Then part 4 deals with possible actions by the ILO, and as later in this webinar, we will seek your views on a possible role for the ILO. I shall also skip part number 4. And then the final bit of the paper deals with the 5 case studies that we shall hear more about later in this webinar. So we skip the challenges and move straight into the recommendations. And here in 2 slides, I will cover recommendations pertaining to the context within which labor inspectors operate. And the first recommendation is that governments need to show the political will to address unfair recruitment. And they can do this through comprehensive legislation that covers all sectors of the economy, and also the allocation of substantial resources for enforcement. Ideally, legislation should spell out minimum recruitment requirements, including no fee payment by migrant workers. And it should spell out what is abusive recruitment. Legislation could even make it an offense to recruit through non-licensed recruiters. Second, globally, there is a reality of subcontracting and outsourcing of migrant workers. And this pushes liability for abuse down the recruitment chain and complicates monitoring and enforcement. So enhanced transparency and enhanced due diligence standards in subcontracting may facilitate monitoring of recruitment of migrant workers. Number 3, in many countries of destination, migrant workers are tied to a particular employer for their work visa. This gives exorbitant powers to the employer and may lead, for instance, to salary deductions to recoup the recruitment costs that are paid by the employer. If migrant workers would be allowed to resign with due notice, rather than be tied to an employer, there would likely be fewer recruitment abuses to monitor. A number of countries apply biometric registration of migrant workers. The same technology could be applied to recruitment agencies. This may help to sift out the Phoenix agencies that may pop up after abusive recruiters have been closed down. Standardized employment contracts at origin are not necessarily accepted at destination. So it is important that these standard contracts are coordinated between countries of origin and countries of destination. If done, this could help to prevent abuse and could facilitate the monitoring work of labor inspectorates. Finally, where memorandums of understanding are in place between countries of origin and destination, they should spell out a role for labor inspectors as part of monitoring modalities, and that currently is rarely the case. Now, in addition to recommendations pertaining to the context within which labor inspectors work, we have a non-exhaustive list of recommendations pertaining to the actual work of labor inspectors. And the first one is that if labor inspectors are to include a focus on recruitment in their work, it is important that this is mentioned in their mandate and that they have operational capacity to do this, in addition to their regular capacity to monitor in workplaces for conditions of work, for occupational safety and health, and for wages and working hours. The capacity of labor inspectors to monitor effectively would increase if they had the authority to conduct inspections at any workplace, in any sector, and at any point of the day. And if they were to do this unannounced, if they would do surprise visits. And if labor inspectors or related authorities had the jurisdiction to monitor also the private recruitment agencies. In many places, labor inspectors would need tools and training to determine what constitutes abusive recruitment and how this can be detected. For instance, by working with indicators of unfair recruitment. Fifth point, detailed licensing requirements for private recruiters should include attention to fair recruitment. And this could include a commitment to no worker payment and a commitment to keep copies of employment contracts. This should help to set a baseline against which labor inspectors can then monitor. Even with limited resources, labor inspectors could operate effectively if they were to target their inspections to problem hotspots. Up-to-date information from a range of different sources and data mining could help such targeting. The effectiveness of labor inspectors can also be enhanced through collaboration with other agencies within the country. However, labor inspectors should guard against serving as de facto immigration officers. Collaboration among inspectors that monitor recruitment at source and at destination could also help to increase the effectiveness of monitoring across borders. And finally, if labor inspectors in their monthly performance reports include attention to monitoring of recruitment, it could help them to show that they are making progress in addressing abusive recruitment. That brings us to the 5 case studies. As you can see, 4 of these case studies deal with licensing and monitoring of private recruitment agencies. The first 2 in black are from countries of origin. Case study number 3 and 4 in blue, they are from countries of destination. And the 5th case study is about workplace monitoring at destination. Cases number 3 and 4 also include a component on workplace monitoring. The first case study is from the Philippines, which is a country of origin of migrant workers. It has a special authority to manage and oversee recruitment of Filipino migrant workers. It is called the POEA. Crucially, recruitment abuse is prohibited by law, and this makes it possible for qualified compliance officers to monitor against these abuses. Candidate recruitment agencies are vetted through interviews with the POEA staff and licenses are issued to agencies that adhere to a code of conduct for ethical recruitment. And inspectors can monitor against this code. Then there's an important point on joint liability, where employers or recruiters abroad abuse migrant workers from the Philippines, there the recruiter in the Philippines can be held accountable. Now, even though there are some questions about the effectiveness of this liability system, it is an important point of principle. Another highlight is an escrow deposit by private recruitment agencies, and this allows for possible legal claims by migrant workers to be settled. The last point I would like to highlight is that the POEA keeps a list of private recruitment agencies updated publicly, including information on their status in terms of sanctions and rewards. Vietnam is another country of origin of migrant workers that has spelled out in law a number of prohibited recruitment acts against which the Department of Overseas Labor can monitor recruitment agencies. Vietnam offers an interesting set of licensing requirements for recruiters that I've listed in black on the slide, including a security deposit, the absence of a criminal record pertaining to labor abuse, the obligation to protect the rights and interests of migrant workers, and an obligation to monitor and supervise the performance of the employment contract. Now, interestingly, the private recruiters, they will have to sign a labor supply agreement with the employer abroad. And that agreement needs to meet a minimum labor standard. And importantly, the individual employment contract of the migrant worker needs to be in line with that earlier agreed labor supply agreement. And that then offers a tool to inspectors to monitor against. Importantly, labor inspectors have the authority to impose administrative sanctions, and there is proof that they do so. That brings us to the third case, the UK, country of destination of migrant workers. The UK adopted the Gangmaster Licensing Act against abuse of foreign laborers. This act is extremely proactive in that it spells out as a criminal offense to operate without a recruitment license and for employers to use the services of a non-registered or non-licensed recruitment agency. This is very different from countries that have a licensing system, but that also de facto allow informal sub-agents to operate. The act even has an extraterritorial dimension in that it requires private recruiters from countries of origin that have a link with the UK to also apply for a license with the Gangmaster Licensing Authority. The licensing standard includes the requirement to not maltreat migrant workers and to not charge them recruitment fees and costs. The GLAA takes an intelligence-led approach to target recruitment agencies for inspection. And finally, very importantly, the officers of the GLAA, they have a substantial authority, including the authority to conduct arrests, just like the police. Canada is another country of destination of migrant workers, and there we have zoomed in on Manitoba province, where monitoring of recruitment of migrant workers is done and managed through the Employment Standards branch. The legal arrangements to achieve fair recruitment are quite similar to those in the UK, with a ban in law on the payment of recruitment fees by migrant workers and a requirement for private recruiters to license. The licensing requirement includes the payment of substantial bonds against possible migrant worker claims, and any recruiter must hold a professional license through a membership of a professional association that issues accreditation. So if a recruiter abuses a migrant worker, that also puts at risk their professional license to operate in Manitoba province. Importantly, employers who host migrant workers, they have to register and obtain migrant workers through licensed recruitment agencies, or they have to recruit them directly. What I find strong about this particular case is that a high level of transparency is required not only of the recruiter, but also of the employer in terms of documentation. And this again offers entry points for monitoring. Finally, the ESB conducts upfront investigations of recruiters at the time of registration, and it even interviews migrant workers upon arrival in Canada, and again later on during workplace visits. Belgium and the Netherlands are also countries of destination of migrant workers, and as they have similar approaches, we have combined them into one and the same case study. Both countries offer workplace inspections through specially trained social inspectors. And these are skilled in spotting indicators of forced labor and trafficking, such as contract substitution, debt from recruitment, and prolonged passport confiscation. These social inspectors work together with a range of specialists from various disciplines, including municipalities and the police. These inspectors have the authority to make unannounced surprise visits in any workplace, in any sector, and at any point of the day. Belgium and the Netherlands do intelligence-based targeting of work sites, just like the UK. And it is worth highlighting for Belgium that they have monthly committee meetings with a set of core informants to review the targeting of workplaces for inspection. The capacity to inspect will always be limited, but it is safe to say that both these countries have quite robust capacity to inspect compared to many others. And this allows for more time per monitoring visit, and also for time to do follow-up reporting. And we believe that such reporting is essential when wanting to reach a verdict in case of labor disputes. Finally, the inspectorate in Belgium sets targets for the number of inspections per year, while in the Netherlands they set targets for the detection rate on the number of inspections. And with that, I would like to give the floor to Miriam to facilitate further discussion on the 5 case studies.
Thank you, Hans, very much for your presentation. I find very interesting looking at the different cases, how we do have very interesting and innovative approach from the different countries. And we have the chance today to have most of the experts representing those cases. We started to have also some questions. I see some hands that started to raise. I also see some questions in the chat. I would like, if you don't mind, participants, maybe to allow me first to give the floor to our external speakers that join and want maybe to say further on the different cases presented by Hans, and then we can open the floor right after. So let me maybe start with our first expert, and the first case also I think you presented, which was the case of Philippines. And we have the chance to have with us today Attorney Francis Ron de Guzman, who is the director of the Anti-Illegal Recruitment Branch from the Philippines Overseas Employment Authorities. So I hope you can hear me, Attorney, and you can maybe put your mic on. And please, of course, do you hear me well?
Yeah. Good.
Hello, how are you doing?
I'm good, I'm good.
Good to see you.
Manila.
Thank you very much for joining. I know it's very late on your on your side.
It's okay, it's just around about 11 o'clock in Manila.
Just. So, thank you very much for joining us. And maybe to go further, you know, of the presentation done by Hans, I would like maybe just in maybe 5 minutes to ask you if you could elaborate on how the joint and several liability system works, and whether there is any proof for instance, that private recruitment agencies are held liable in case of abuse abroad. Can you maybe say a little bit more on that?
Okay. I guess before I jump into the discussion on the JSL, or the joint and solidary liability as we term it, I guess I could pull back a bit on the issue, or at least on the issue of licensing and the necessity of licenses and accreditation of foreign employers. For starters, in the Philippines, prior to deployment overseas, or prior to for an agency, or at least an entity, to be able to recruit workers or Filipino workers to work overseas, they need to have a license, as mentioned by Hans a while ago. Sans that license, or absent that license, any act of recruitment would be considered as illegal. On the other side, of course, on the destination country side, prior to deployment to any employer in the destination country, the employer must be accredited as well with the Philippine Regulating Agency, or the POEA, or the Department of Labor in this case. So I'm starting from that point of licensing the local agency here in the Philippines and accrediting the foreign employer in the country of destination, or in the receiving country, because that is that ties up. Okay, that basically ties up the legal relationship of the joint and solidary liability. The licensed recruitment agency in the Philippines would be legally tied to the accredited foreign employer in the destination country. So the joint and solidary liability basically means that any monetary or contractual obligation that is owed, or at least that is obligated from the side of the foreign employer, would be borne as well, or would be, or could be charged as well, to the licensed recruitment agency here in the Philippines. So why is that so? I mean, from the discussion and from the way that we do things here in the Philippines, it is quite obvious that foreign employment, or at least overseas employment, is a mechanism or a setup wherein migrant workers would have limited rights and would have limited, because they're not citizens in the country of destination, they would have limited rights, and they would have limited capacities in the country of destination. Another thing would be because there is a time-bound contract, they might not, or they may not be able to pursue the contractual obligations or monetary obligations that are owed to them against the foreign employer, because at the end of their contract, their visas would also expire. So therefore, they need to go back here to the Philippines. So given that context and given that scenario, the mechanism for the joint and solidary liability, as enunciated in the various Supreme Court cases and in the various issuances by the Philippine government, holds it in such a way that the licensed recruitment agency could be held liable for any monetary or contractual claim against a foreign employer. And is it a success? Going into the question of Miriam, yes, it is a success in such a way that it becomes a mechanism that would be easier to pursue. It's an easier mechanism to pursue, because the worker could then opt to pursue the case against the recruitment agency. And because the recruitment agency is regulated and has a license to operate, the recruitment agency deems upon itself, or takes upon itself, that it is actually jointly and severally liable with the foreign employer. So they understand that it is their liability, whatever the contractual obligation of the employer is. So they would now be able to subsume, or at least gather that obligation, and at least live up to that obligation in pursuit of the rights of the worker here locally in the Philippines when the worker returns here. So we've had a lot of success stories of filing those cases. At least in our office, in the Philippine Overseas Employment Administration, in our office, they would be able to pursue that case because at the very least it is an administrative case, an administrative offense, that if the agency is not able to provide for the contractual obligation or monetary obligation, their license would now be at risk of being suspended or canceled. Hence, they would no longer be able to operate. So we tied it up in such a way that the license itself of the agency is at risk if they are not able to assume the JSL or the joint and solidary liability with the foreign employer.
Thank you very much. I think it's very interesting to listen to you, and I'm quite sure also some of the other, of course, participants would have maybe some questions for you, and also can rely on what you're saying according to their own experience. I maybe just have a very last questions for you before moving to the next expert. Do you want to share other highlights, or you feel Hans maybe did not touch upon, or maybe also mentioning some of the challenges in the work that, of POEA to ensure fair recruitment?
The setup and the mechanism is already quite advanced. The way we do things in the Philippines, we do the licensing accreditation setup since roughly around in the mid 90s, in the early 1990s. We've already been doing it, but of course there would always be that aspect of trafficking, of illegal recruitment, this sort of stuff. That's why it's very important, as mentioned by Hans, that it is very important that inspections are actually conducted, because it is a regulated industry, as I've mentioned. There are those that are actually just posing or just fronting as legitimate businesses to become recruiters. So the challenge is, of course, how do we sift it? How do we weed out the unethical from the ethical? How do we weed out the bad eggs from the good eggs, so to speak, the good ones from the bad ones? So it has always been a challenge, and I guess we always need to refine and to fine-tune the system, because there would always be that opportunity, and there would always be that difficulty that once or twice in several instances, there would be those who would actually attempt to pose or to front as legitimate recruiters, but then again, they would not be recruiting fairly or ethically. So that's why it's always a continuous improvements process for us in the government.
Thank you very much, Francis, for your testimony, and please stay with us. I'm quite sure we want to hear more from you when we will open the discussion with the other participants. And thanks again for, despite the time, to join the webinar. Maybe let me now give the floor, in a way, if I can say virtually even more, to the next case that was covering Vietnam. And we do have a video with the testimony of Mr. Liem. So Mr. Liem is also, he's the DDG of the Department of Overseas Labor in Vietnam. He's also with us today. Thank you very much, Mr. Liem, to join us, together with a colleague from the National Office in Vietnam, Matthew, who will also, if needed, answer to some of the questions you might have. But otherwise, I will ask right now maybe my colleague to put the videos on, and having this very short interview from Mr. Liem, giving us more information on the Vietnamese case.
Trong thời gian qua, thì công tác thanh tra kiểm tra việc chấp hành quy định pháp luật người lao động Việt Nam làm việc nước ngoài đã được tăng cường và đem lại những hiệu quả tích cực. Đặc biệt là cái tình trạng vi phạm pháp luật trong lĩnh vực này đã giảm đi nhờ một số lý do sau. Hệ thống pháp luật về người lao động Việt Nam làm việc nước ngoài đã được sửa đổi, bổ sung và hoàn thiện. Việc sửa đổi bổ sung pháp luật vừa rồi của luật người lao động Việt Nam làm việc nước ngoài thì đã quy định những cái hành vi bị nghiêm cấm đưa lao động đi làm việc nước ngoài, như là việc lôi kéo, dụ dỗ, hứa hẹn, quảng cáo sai sự thật để lừa dối người lao động. Thứ hai là tổ chức xuất cảnh cho người lao động nhằm để cưỡng bức người lao động, cũng như là bóc lột hoặc là mua bán người lao động. Thì đấy là những cái quy định cấm. Và một cái nữa là cái việc là phân biệt đối xử, xúc phạm danh dự, nhân phẩm của người lao động. Ba là quy định là nghiêm cấm việc thu tiền môi giới từ người lao động. Công tác tuyên truyền phổ biến pháp luật được đẩy mạnh bằng nhiều hình thức phù hợp, như là thông qua các cái hệ thống thông tin truyền thông, cũng như là hội nghị, hội thảo, rồi các cái ấn phẩm kể cả bằng sách rồi bằng tờ rơi cũng như là các cái video. Và đặc biệt là Cục Quản lý Lao động ngoài nước cũng đã phối hợp với các cơ quan trong việc là tổ chức tập huấn cho các cái cán bộ của doanh nghiệp cũng như là cán bộ của địa phương về các cái nghiệp vụ cũng như là cách thức tư vấn cho người lao động đi về nước ngoài. Thêm một cái nữa là cái hệ thống các cái thanh tra từ trung ương đến địa phương, như là từ có thanh tra Bộ Lao động, thanh tra Cục Quản lý Lao động ngoài nước và thanh tra của Sở Lao động địa phương, áp dụng các cái công nghệ thông tin trong công tác này, như là việc là xây dựng hệ thống cơ sở dữ liệu. Đồng thời vừa rồi thì chúng tôi, Cục Quản lý Lao động ngoài nước phối hợp thanh tra Bộ xây dựng cái phần mềm để cho các cái doanh nghiệp tự kiểm tra, và thông qua đó thì cũng nắm bắt được tình hình hoạt động của doanh nghiệp, kịp thời uốn nắn cũng như là hướng dẫn, và có thể phát hiện thì sẽ tổ chức thanh tra trực tiếp tại doanh nghiệp để xử lý các vi phạm của doanh nghiệp. Thì một cái điểm cuối cùng là thời gian qua thì cái cơ sở vật chất cho công tác thanh tra kiểm tra cũng được quan tâm và được nâng cấp.
Thank you very much, Marion, for sharing the screen and the videos. I think it's very interesting indeed to hear from this self-inspection system implemented by Vietnam, and I'm quite sure if you do have any other questions, please don't hesitate. Our colleagues from Vietnam are here to answer to it. But without further ado, maybe let me give the floor to the next expert. And I will give the floor to Mr. Daryl Dixon, Director of Strategy of Gangmaster Licensing Authorities. And Mr. Dixon, thank you very much for joining us for this webinar today. We will be very interesting, I mean, in addition to the presentation done by Hans, to know a little bit more on the work you're doing about monitoring the licensed recruiters in country of origin. So how do you proceed for doing so?
Certainly. Excuse me. Firstly, just to put it in context as to how we undertake that monitoring in the UK of UK businesses, so you can see why it's important. The GLEA licenses businesses, employment agencies that supply workers into the agricultural sector, and it assesses the compliance of those businesses against our licensing standards. And those licensing standards cover all aspects of UK legislation that apply to the relationship between the employment agency and government paying taxes and things like that, as well as the relationship between the employer, the agency, and the workers in relation to national minimum wage, health and safety, and contractual matters. The section 3 of those standards actually incorporates the ILO's forced labour indicators as a core element, because the key thing about our licensing standards and our inspection regime is to prevent exploitation of workers. When a company applies for a GLA license, we are going to inspect them against those standards, but the first stage that we go through is to check with colleagues in other government departments in the UK for any information on the business that's applied for a license, to see whether it is compliant with regulations as understood by those other agencies, and that information helps us to make an assessment on whether to issue a license. It's complicated, though, if the agency that's applying to us for a license is based outside the UK, because in those circumstances, we won't have information from other UK government departments on that business. But it is important for us to understand whether the business, where it's operating in the country of origin, is compliant with the domestic labour laws. And there it's important for us to make contact with the labour inspectorates in the country of origin to find out as much information as we can about the operations of the business that's applied for a license, and therefore to use that to determine whether to issue a license. Of course, without that information, although we still inspect and speak to the business, it can raise a risk that if we don't know that information, there is a greater risk of exploitation of workers that we might not otherwise understand. Now, that's quite complicated for the UK now, because since we were created in 2005 and went operational in 2006, the majority of workers coming into the UK were from European Union countries under the freedom of movement. And that has now ended since the UK decided to leave the EU. But although the UK has left the EU, it still requires more workers to come into the country for the agricultural sector, and where we have a lack of workers. It's not going to recruit those workers from European Union countries because of the departure from the EU. And therefore, when it created a new seasonal workers scheme, it agreed that those operators who have to be licensed by the GLA as well could recruit from any country in the world outside of the EU. And so we're currently dealing with applications from companies based in Nepal, South Africa, the West Indies, as well as now supplying workers from Kazakhstan, Kazakhstan and Tajikistan, and all the range of countries that we haven't previously had direct contact with. And so that makes our work more complicated, because we have now got to re-establish or establish for the first time relationships with the equivalent labour inspectorates of a wider range of countries in order to try and obtain the information to assist us in satisfying our rules that those businesses are not in a chain of exploitation. And that can be more complicated because we need to understand what the laws are in those countries, where perhaps some of them might allow fees to be charged against workers, whereas our rules will refuse a license to any business that would charge workers. So understanding the legislation in those countries is important. There are a range of intermediaries that can operate, certainly in our recent experience with Nepal, where people get involved in the recruitment of the workers who aren't themselves recruiters, but are financial brokers who are arranging loans, and the manner in which they operate can still contravene our regulations. So it becomes a more complicated situation for us now in the UK to monitor the compliance of businesses applying for licenses that are outside the UK, but nonetheless, it's still a key requirement for us to do so in order to make sure that we don't license businesses that might be exploiting workers.
Thank you very much, Daryl. I think it's very interesting what you highlighted indeed of the consequences, of Brexit. And once we wouldn't necessarily, I think, see first the impact on recruitment. And I think you highlighted something which is very concrete on the reality of Brexit. Do you think this is maybe the biggest challenge that you might, face to do today in the work of GLA to ensure fair recruitment, or are there other challenges you might want maybe to highlight it?
It is one of the biggest challenges we've got, because we had done a lot of work to create a network of contacts with other labour inspectorates across the EU, and the work that we did in that was fostered and supported by working with colleagues in the Netherlands, where the Netherlands colleagues and ourselves co-led activity against forced labour through Europol. So we were able to create a great network between the member states. So now we're outside of that family of labour inspectorates, if you like. We still have some contact with them, because workers that came to the UK within the last year or so could still be entitled to stay, but also their exploitation may be occurring, but it may be a couple of years before that emerges and they feel confident to tell us about that. So we still need to maintain the relationship with those other labour inspectorates, but it is becoming more complicated because any country in a business anywhere in the world could apply for a license, and we have to just spend a lot of time to satisfy ourselves of their compliance. So that is probably the most complicated area. The other thing to say that is a complication for the GLA is, of course, the fact that, as was explained on Hans' slide, we do have wider powers. Now, we are a licensing body. We license businesses that are compliant with our standards that supply workers into the agricultural sector in the UK. The UK is made up of 3 different legal jurisdictions: Northern Ireland, Scotland, and then England and Wales. Our licensing requirements apply in all of those areas. In addition, though, to the licensing powers that we have, we also have wider policing powers that were referred to on Hans' slide. These allow us to investigate any forced labour. Now, that's in relation to a business or an individual that's exploiting workers, but is not in the agricultural sector and where we don't need a license. But because of the legal jurisdictions in the UK, those powers only operate in England and Wales. So the other big challenge for us is ensuring that we work towards getting equivalent powers in those other legal jurisdictions, Northern Ireland and Scotland, so that we can tackle labour exploitation anywhere in the UK in a consistent manner.
Thank you very much, Daryl, for that. And please bear with us. And I'm quite sure it would be very interesting to hear more from you in the coming minutes. But let me maybe move to, if you don't mind, to Canada, and in particular to Manitoba, and to listen to Mr. Jared Beckley, who is the manager of the Claim Investigation and the Employment Standard Department of Labor, Consumer Protection and Governance Services. Jared, thank you very much for being with us today. It has been, it's particularly early on your side. I would just maybe to ask you specific questions in addition to, so in the case of the Manitoba case, in addition to the licenses requirement for recruiters, that was very interesting. I was very interested to listen in Hans' presentation that employers who host migrant workers also need to register. Both sets of factors need to provide a series of documents which offer, and Hans highlighted that very clearly, a lot of transparency. Could you maybe elaborate a bit on these registration requirements?
Yeah, I'm happy to do that. Thank you, Miriam. Thank you to everybody for having me. It's wonderful to be here to talk about the Manitoba model, but also to hear from others and their experiences going through the same things and trying different ways we're interested in learning here as well. So yeah, thank you to Hans for that wonderful technical brief. I think he covered a lot of what we do already. So I do want to, I'll just glaze over it here and then get to your question. But Manitoba is just one province in Canada. There's actually 10 provinces, 3 territories, and then of course the federal government as well. So we have a lot of different jurisdictions with different regulatory authorities. And what we found in the early 2000s is that really the issue of migrant workers and abuses and fee charging wasn't really being dealt with, and so we were the first to try it. So it's become known as the Manitoba model here in Canada, and other provinces and territories have further adopted what our practices and hopefully improved on them. So we have a registry for employers, we have licensing for recruiters, and we have the ability to go and do proactive investigations wherever and whenever we wish. Those are key measures for what we do. And what we were really trying to do with the legislation is we were trying to bring the liability for abuses, fee charging, and any other issues within our jurisdiction. I was just hearing from Daryl in the UK that they've got an interesting scheme trying to figure out what's going on in other jurisdictions. And that's what we were hearing, is that a lot of fee charging is happening in countries of origin or somewhere along the way in the journey to Canada. And so what our legislation does is bring the liability for those fees to the individuals in Manitoba who are either doing recruitment or to the employers who are acting without a licensed recruiter to their own peril. So the registry is the first part of that. It's an administrative tool, frankly, just to get set up so that we know who is hiring temporary foreign workers. But it's also an opportunity for us to carve out already known to be bad actors. We are employment standards, and so we know people who don't pay wages properly. We wouldn't allow them to hire the most vulnerable sector of workers, migrant workers. It's an opportunity to identify unlicensed recruitment before it's happening. So you are required to be licensed to be a recruiter in Manitoba. An employer can take on recruiting a foreign worker without a licensed recruiter, meaning that they're doing it themselves. But then, of course, they wear the liability for whatever is happening to that individual, that worker, along the way from their country of origin to Manitoba. And so it's not something I'd necessarily recommend to employers, and we have an opportunity to discuss that with them because they have to come and get registered with us. And we can turn them to our website, publicly available information of all the licensed recruiters, the individuals who will take that liability on for themselves if you choose to use their services. And so, yeah, it's kind of a consumer protection opportunity for employers who certainly don't want to be complicit in abuses occurring. And yeah, and then there's a lot of information that we can get from that as well. You're required to disclose any parties that you're working with, your business structure. You have a record keeping requirement for not just who you've recruited, but all of the employment contracts that you've ever had with them, any of the expenses that you incurred, and we would expect that there should be some and that you should be able to produce that when we ask for them. Otherwise, probably further investigations will ensue. So the registry is important. And the other issue about the registry is, and I think was mentioned in Hans's technical brief, is that there is a firewall of sorts that ought to exist between employment standards branches or labor inspectorates and the immigration side of government. We're not trying to see that somebody's, without paperwork becomes deported. It's not our issue. We want abuses to be prevented. And so the issue with that firewall, though, is that there's a communication lapse that occurs. We don't have all the information at all times that the immigration side might have. And so the registry at least gives us the information about where foreign workers are going and allows us to maintain that firewall, as it were. We are trying to still overcome some of the issues that creates. So if I could, I'd actually like to use the time to really talk about some of our challenges, just to get them out there, and maybe that'll be part of a discussion that ensues. But communications are a big one. So I think it was mentioned that there's MOUs with countries of origin and destination, and that's great. I think they're somewhat difficult to maintain, and there's some communication issues there. And I know that we've worked with the Philippines, for instance, in the past. But right now, what we're dealing with is MOUs of sorts or information sharing agreements internally to Canada. So one of the things that happens when you regulate one area of an immigration concern, and in Manitoba, we work with mostly closed work permit, temporary foreign worker program migrant workers. There are a lot of other immigration streams that bring people into Canada and Manitoba. And so once we regulate that one area, it's probable, and we think, well, we've seen it before, that the area of exploitation shifts, right? And so we have to be able to communicate with other areas that might regulate those immigration streams, like the federal government, or if Manitoba has a good regulatory model, someone might just shift their activities to the province adjacent, or any of the other provinces. And so we have to be able to communicate with them as well. And so we have actually now secured an information sharing agreement with the federal government. But there's a lot more work to be done there, because I think that communication is key, not just interjurisdictionally between countries, but within the country itself. Resources are always an issue. When we first launched the Worker Recruitment and Protection Act, that's RAPA, as you'll see it in the technical brief, that's the act that we're talking about here. we had a team dedicated to it, and that was 14 years ago. So that team doesn't exist anymore, just for various political reasons and budgetary changes and et cetera. And so we've had to find a way to continue that work within employment standards while we have other portions of our mandate to fill. And that's just always going to be an issue. And I think one of the other things that that gets mentioned in the technical brief that we all know is that getting workers, the migrant workers themselves, to come forward and be part of an investigation is oftentimes an issue. Of course, there's fear of reprisal, especially when you're on a closed work permit and you're beholden to that employer. There's a potential trust of government issue, and less talked about. But I think we do see it in our work. It's not to say that it's the lion's share of it, but sometimes there's some level of a worker being complicit in what's happening. It's not to say that they're not being abused, but you do have perhaps an advantage of, say, jumping a queue immigration-wise to arrive in the country of destination by paying money that you shouldn't otherwise have to pay, of course. And so perhaps you're not that willing to come forward and discuss it because of some advantage it's given you, despite the fact that, of course, it is abuse. Those are some of the things that we try to deal with. And we deal with them through those measures. Again, we can proactively investigate wherever we want. We can go and if we find where a worker is living even and visit them there offsite. We can go anywhere in the province at any time to speak with anyone about these issues, and that's what we try to do.
Thank you very much, Jared, for highlighting. I think your last sentence is also, I mean, seeing very much the highlights, you know, of your case. But it's good as well that indeed you addressed some of the challenges. And I was taking some notes, and I think it's a lot of echo for many participants. I mean, for instance, we did in fact in the chat, one of the participants highlighted the questions related to the resources. I think this is something that for sure is the reality in many countries, you know, sometimes the lack of resources you might have. And I think it's very interesting as well that you highlighted very strongly the importance of communication and how this is maybe a challenge that again can be seen in many cases and in many different contexts and countries. Without further ado, I would maybe ask, I know that we do have questions. I clearly noted the different experts and colleagues who want to take the floor, so make sure I didn't forget you. And I just want maybe very quickly to ask my colleague again, Marion, to put the very last video, and this is the testimony from Mr. Koen van Oosterlegger from Belgium, who is a strategic advisor on social inspections. And then after this very short video, we will move to the discussion with the audience. Thank you again, Jared.
One of the things that makes inspections efficient in Belgium is the cooperation between the various inspectorates and police forces. These various services, each with their own specialty, carry out joint inspections, because one inspectorate is more specialized in remuneration, another in the employment of foreign workers, another in the collection of social security contributions, etc. In this way, knowledge is bundled and thorough investigations can be made. In each legal district, the different inspectorates meet about once a month. During these meetings, illegal constructions are discussed and joint inspections are organized. Sectors that are more vulnerable to frauds are inspected more often than other sectors. The same goes for known malicious employers by findings in the past, and also by comparing data, irregularities can be discovered, so there is also a way to determine the targets. These meetings are led by a magistrate specialized in labor law. It is also that magistrate who can prosecute detected infringements in court, and fines can go up to 48,000 euro for each foreign worker who is not employed correctly. These high fines can have a deterrent effect. Every year, approximately 10,000 joint inspections are carried out, and this is in addition to the investigations carried out by each inspectorate separately. Inspections can occur at any time of the day, 24/7, because malicious employers try to avoid inspections by, for example, employing or exploiting illegal foreign workers at night and in the weekends. So it goes without saying that inspectorates also have to operate at these times. And finally, not unimportant to mention, inspectors in Belgium have the right to enter a workplace unannounced. The employer cannot refuse them access. The challenge lies in the exchange of data with other services. Europe has very strict privacy legislation, which does not make it easy to exchange personal data with other inspectorates. Exchanging data requires special authorization, and making such a request for authorization is not only very time-consuming, it also requires extensive knowledge. This difficult procedure creates an obstacle to the exchange of data between services. However, exchanging information could be an important source for detecting fraud and abuse in a more efficient way. I'm not saying that little information is currently being exchanged, but there is certainly room for improvement. For example, an illegal immigrant who is working undeclared will probably also be paid with black money, and obviously not according to the applicable salary standards. So data from the tax authorities could provide interesting information for the labor inspectorate and vice versa. Another example, access to data on housing could also be an interesting source. Foreign workers who were exploited often live with others in miserable conditions and poor housing. I can give many more examples of why the exchange of data can be very important. It is my conviction that if all the data present in all the different government departments in Belgium were to be combined and cross-checked, fraud and abuse could only come to light more quickly and more efficiently.
So that was the intervention from Mr. Van Osselaer, who unfortunately was not able to join the webinar, and therefore he has prepared this short video. I think what we see from his intervention that he also very much highlighted the importance of the unannounced visits, including those outside normal working hours. And I see that we started to have some questions in the chat, and also some participants who raised their hand. And maybe I will kindly ask Hans, Maria, and as well Javier and Joachim, if for any you can maybe provide some comments. Maybe I see the first questions from Mr. Shokri Wali. Maria, maybe this one for you. Est-ce que le travailleur, qu'est-ce que le travailleur migrant peut gagner en termes de travail décent?
What the migrant worker can gain in terms of working decent work. Maria, can you please elaborate more on this? Yes. Okay.
Well, I mean, I guess that the point here is really to make sure, I mean, that the migrant worker is treated under the condition of equality of treatment in the country of destination, so that, you know, the moment that he or she arrives in the country of destination, it's not already coming with you know, situation of abuse and disadvantage. So certainly, you know, addressing recruitment related abuse will increase, you know, the chances of the worker to access decent work at the country of destination. And perhaps also, you know, make sure that the employers and recruiters, you know, are all acting on sort of an equal level playing field, you know, at destination, that there is no unfair competition between workers, migrant workers and and national workers. And I also saw a question in the chat at some point that pointed at the fact that in many countries, once the migrant worker is at destination, is subject to the same legislation as nationals. And this is certainly true, in most countries. That's what happens. But I think when it comes to enforcement and detecting abuses, one has to recognize that migrant workers have specific disadvantages in terms of accessing those same rights that are granted by law. So whether or not, indeed, I mean, certainly the law grants them the same level of protection. In practice, this is sometimes made more difficult for the situation that migrant workers have, and also for the specific characteristics in terms of lack of knowledge of protective legislation, also lack of knowledge of available services, and being placed in more isolated places where they have less support services accessible, not to mention, of course, also language and cultural barriers that can make it more difficult for them, not only to speak up, but also to receive adequate services and protection. So yes, maybe I'll stop there. I did hear a lot of commonalities, among the different speakers, around the need to share data and information and the challenges that are related to it, around the need to collaborate across government services, and certainly, a call for effective regulation and licenses criteria for recruitment agencies. I'll stop here and let other experts to come in.
Merci Marion. Merci Maria. Je vais continuer en français puisqu'on
I will continue in French because I see some participants having raised hands. We have a question par Ahmed Assaoui from Tunisia. I don't know if he wants to speak. I saw that there was a comment too. Good morning, everyone. I'd like, first of all, to thank the speakers for their presentation. It's a very important topic, the one we are seeing today. Most of countries confirm the importance of these topics. So this is a very relevant topic, and we are trying to work on them, and we've been working on them for years. So we have a legal framework which exists since 2010. We have tried to respect the general principle of the Convention 141 of the ILO, and we know that private recruitment agencies are fully involved in the procedure. We have also stressed the need of giving workers services for free, and we have a dossier, really a file. An authorization should be submitted to the private employment agency before the recruitment. And we have really a huge file that will be finalized, and we have also some rules about financial obligations. We have a commission working on this. A commission has to give advice, and the ministry has to authorize the private employment agency and in order to proceed. So we are the Ministry of Employment and Professional Training, and we are also part of the Ministry of Social Affairs. So we really have the control on these agencies. And we really have strict rules for them to be followed. We have created an inspectorate network in order to carry out inspection and control of private employment agencies. I believe that all speakers speak about labor inspectors, but I think it's important to speak about the inspectors for the private employment agencies. So we really need to speak about labor inspectors or private employment agency inspectors, because we can find these two profiles. It depends on the countries. In our country, these two kinds of inspectors are really important. And for employment of foreign workers in Tunisia, we have the labor inspectors intervening, while for workers who want to go abroad, we have the private employment agency inspectors to intervene. So it's important to understand also the importance of private-public partnerships. So we need collaboration. It's important to have a partnership between the public and the private domain, and we need tools and means in order to implement everything needed to better control abuses by recruiters, abuses by brokers, intermediaries. So we are trying to create an online platform for private employment agencies. And on this platform, we have all information about placement that will be carried out. That's it. Thank you very much. Thank you. It's a pleasure to have you here with us. I'd like now to give the floor to our participant, our expert, coming from Qatar. I don't know if you hear me.
Yes, actually, I hear you. Really, thank you for giving me the opportunity.
Thank you. Thanks to you for your patience.
Yeah, I'm Mahmoud Siddiqui, the representative of Ministry of Labor. I'm really happy to share with you very shortly our experience in monitoring the private recruitment agencies. Qatar has a comprehensive legal framework to promote fair recruitment, in particular a ministerial decision that regulate the licensing and monitoring of private recruitment agencies in Qatar is approved and it's sanctioned already to complement the legal provisions. The Ministry of Labor implements a rigorous licensing and monitoring system to regulate private recruitment agencies. Our licensing system requires labor recruitment to obtain a 2 years license after meeting certain criteria such as proof of agency's financial and professional capacity. The ministry has also taken strong action against agencies for non-compliance, such as when an agency receives any deduction from workers or presents fails information and documentation. The ministries has dedicated inspectors to monitor and inspect private recruitment agencies. Within the first 4 weeks of this year, a license of 45 private recruitment agencies have been revoked to further strengthen the ministry's licensing and monitoring system of private recruitment agencies in Qatar. The ministry has shared the collaboration with, started the collaboration with the ILO the ILO project office in Doha. In the coming weeks, we will start an assessment of the operation procedures and mechanisms used to licensing, monitoring, and enforce private recruitment agencies in line with the international labor standards. Any gaps and challenges identified through the system will be used to develop strategies and tools to further strengthen the capacity of inspectors. Really, thank you for giving me this opportunity. Thanks.
Thank you very much, Mr. Al-Siddiqui, for sharing your experience from Qatar. We still had two persons who raised their hands. So we have Mr. Ouali, and we have three persons who raised their hand. Je vais peut-être repasser en français dans un premier temps. Monsieur Ouali, je vous passe la parole.
I will switch into French. Monsieur Ouali, I will give you the floor. Good morning, everyone. I'm Shukri Wali, Director of Inspectorate here. I'd like to share my experience about inspection in the informal sector. We have the informal sector, which is really huge. And we have women, sometimes children, who are exploited in the agricultural sector, and migrant workers who are exploited in the informal sector in Tunisia. We started working on inspection in the informal sector, but unfortunately we have troubles because we have a lack of personnel, we have a lack of means, and we have to cooperate with other control mechanisms. So social security factors. So we have many services, but we need really to strengthen our staff, our means, because this is just cooperating. The cooperation is the only way to manage the informal sector. So we can work together and we can find solutions, and we can also try to work together in order to ensure fair opportunities. So we really need to have a consultation. We have to work together with other instances. The problem, the hugest problem we have is the lack of means and resources, but we have to find a pragmatic way to solve the problem, to intervene in an efficient way. And we have to ensure decent work for all workers. Thank you. It's important to concentrate, to focus on consultation. Thank you. Thank you, Mr. Wali. This is an important point. One of the challenges we have is the lack of means, the lack of resources and personnel. So it's obvious that we have also the informal sector, which is really huge, and it's important to stress the importance of activity also in that field. We just have 15 minutes, more or less. Probably it's important to give the floor to you, participant, in order to understand what are the main challenges you faced in your work according to your context. So thank you very much for sharing. And you can also use the chat. And if you want to participate and share your
We also have a lot of
experience.
experts from Latin America. It's a pleasure to give the floor to Mr. Oscar Humberto from Peru. Thanks a lot for your participation. Good morning. Good morning. Thanks a lot. Good morning, everyone. In Peru, the labor department I am part of is an organization of the Ministry of Labor and Labor Promotion, and the labor inspection has as a control system for private recruitment agencies. There is also a law concerning migrant workers in terms of purchase percentage and in terms of their participation into the social security. At the moment, it's difficult to apply the legislation because during the last years, the number of migrants has increased a lot, especially from Venezuela. So the reality existing before, we had very specialized professionals coming to the country, and so, well, and we asked them to pay 30% of their income to the social security. But nowadays, these requirements are very difficult to apply to the current migrant workers who have less qualifications. In addition, there are many irregular migrant workers, and in order to recruit these workers, these especially migrant workers from Venezuela, we have to adjust our legislation to issue a temporary work permit or a refugee status. Unfortunately, the informality rate is quite high in our country. It's about 70%, and therefore violations against migrant workers is very high. It's very difficult to hire workers regularly because they have no papers, and labor inspection does recognize the existence of a high number of migrant workers in a vulnerable situation, but the same foreign workers are escaping from the workplace in order not to be identified due to their irregular situation, because they do not want to be deported. We are strengthening our measures through a special group working on child labor and forced labor, focusing also on migrant workers. In general terms, we are establishing special groups in order to enhance this inspection and to reduce the violations of the rights of these people. Thanks a lot. Thanks a lot, Mr. Moreno. It is a very interesting experience. It's true, the case of irregular migrants and the specific case you are talking about workers from Venezuela, and also the problems related with the labor inspection. I don't know if Maria or Javier would like to add something to comment on that, on what Mr. Moreno has just said. Javier? Good afternoon. Since Mr. Moreno has spoken my mother tongue, Spanish, I'm going to answer in Spanish. Oscar, it's a pleasure to see you again. It's always a pleasure to meet you. It's true. During today's session, we have seen very practical examples, as it is the case of Mr. Oscar, about the role of inspection. I would like to sum it up in a couple of minutes. Labor inspection, as we listened from most of our experts, is not a solution to our problem, but it can play a crucial role when we have to identify these bad practices in recruitment of migrant workers, which oftentimes leads to trafficking and forced labor. We can do it in different ways. First of all, we should include specific functions into the work of labor inspectors so that they can intervene in the practices of private recruitment agencies. It implies regular controls on the activities of these agencies. And it identifying illegal agencies. This can be a role played by inspectors, and the second role they can play is determined by their basic functions, that is to say, control and monitoring of the existing legislation. And in this framework, in the cases that migrant workers are identified, they should incorporate also the analysis of the way this worker has reached his or her workplace. I mean, adding information about the recruitment process through which the migrant worker has accessed the workplace. They can do it through any agency or intermediary that can be a practice leading to an identification of the existing problems concerning recruitment problems. If inspectors are not trained about this aspect, the next step would be inform the national competent authorities about what they have identified. It's true, as we said several times, that the problem for many inspectors in many countries is that they focus mainly on the formal sector and not in the informal sector. And most of these problems are found in the informal sectors. That is where inspectors should act. That is why it is very important to establish different principles and plans also to reach in the informal sector, not only to identify these unfair recruitment of migrant workers, but also of indecent working conditions for national workers. I think your comments are very important, very enriching, and I think this exchange really favors knowledge and the fact that the ILO can bring forward its proposals. I'm going to share in the chat the document that Joaquin Pintado was referring to at the beginning. There are the general principles and operational guidelines for fair recruitment, which are a very important reference, and all these general principles can be applied to the inspectors' activities, both in their specific functions and in their general functions. Thanks a lot, Javier, for your comments. Let's see. We're getting to an end. Maybe together with Maria, we can reach some conclusions. We have two comments from Gabriela in the chat. Gabriela, would you like to take the floor? If she can, I'm going to give you the floor. Yes, can you hear me? Good morning, Gabriela. My name is Gabriela Eneya, and I work in Peru.
First of all, it's very important to strengthen labor inspection, but I also was saying that it's very important labor inspection to have access to the rights of migrant workers when they, of course, get into a judicial framework, when the administration of justice has to act. And so those migrant workers must be able to access to justice. So this system of labor inspection with other actors, so that the workers, the migrant workers, can access the law is very important. And talking about private recruitment agencies, it's very important that the inspection can control that those agencies. But at the same time, I think that it's very important to inform the public, because the migrant worker must know which are the private recruitment agencies that have the license to operate. And it is also important to have denunciation channels, how these workers can denounce these illegal agencies. So the information and public information must be always updated. That's very important. Thank you very much.
Muchas gracias, Gabriela, por tus comentarios. Que, Gabriela, tú estás conectado del Perú, justo.
Gabriela, you are from Peru, right? You are talking from Peru, Gabriela? I think, yes, I think that she's from Peru. Okay, thank you.
Différents commentaires qui viennent notamment de monsieur.
Right, I go back to French because we have different comments from Mr. Hesso, and specifically interesting comments concerning certain challenges to which labor inspectors are faced in some African countries. I'm asking to Mr. Ebo to take the floor directly. Monsieur Esso, can you take the floor directly? You can if you wish. All right, all right. Okay, we can hear you. We can hear you. So first and foremost, I'd like to congratulate the ILO for organizing this meeting, because it's being so fruitful for all of us. So this exchange is fundamental for us. So as I was posting, this kind of issues usually raise a lot of interest because it shows a strong participation of experts and consultants. I see there are 30 countries connected. And as a matter of fact, we need to look at our reality when we listen to all these exchanges and see what we can apply. So the reality, at least for our country, is that the number of abuses is so high, and not only for informal workers, but also for formal workers, right? So even in the licensing of agents. So there are multiple abuses and there are multiple forms. So unfortunately, the legislative framework which is in force now is not able to counter these abuses. So it is less strict for recruitment and for agencies in particular. So for me, recruitment, on the contrary, is one of the main indicators of abuses. In order to understand whether and where there were abuses along the recruitment chain. And then there were some proposals for a specific regulation of licensing for employment agencies. So this could be one way in which, let's say, the black market, so to say, of illegal recruitment agencies could be at least mitigated, and without forgetting that there are some sectors that are more affected than others. So, for example, the oil sectors in different countries is one of the sectors where we can mostly find abuses, at least in the countries I work with in Sub-Saharan Africa. So this means that all the actors should be involved in this change. So representatives of the workers, civil societies, social partners. And of course, I don't know, I don't have specific indications on that, but I know that there are many irregular workers, even in regular sectors like the oil sectors. So I hope that something could be done. So that's what I wanted to say, and I hope this can help the work of all the colleagues, and I thank the experts that could put on the table the interesting ideas. So of course we will try to learn from the lessons and to improve the situations in our countries. Thank you. Thank you very much for taking the floor, and thanks for your interesting contribution. And this allows me to make a linkage with what I wanted to say next. As I said before, we're almost at the end of our time together. So the main goal was to learn more about this issue through the direct experiences of you participants and the experts. Of course, for us, the task will be to, of course, be in contact with you starting from tomorrow on and understanding what your specific needs are. So we want your feedback. And as I see that we still have 10 minutes, not more than that, before wrapping up, may I leave the floor to Hans again, because after hearing all these plethora of interventions and comments, I'd like to have your own comment, and so I leave you the floor.
Thanks, Miriam, and thanks for extremely rich comments by such a diverse group of speakers and experts, extremely rich. I feel we could talk on for a couple more hours because there is so much more to learn from each other, and I feel there is a real wish for many to contribute more than we have been able to do up until now. So thanks very much. I want to keep it extremely short, and I've been thinking about trying to capture some of the main messages into maybe one particular word. And if I were to choose that word, I think it would be the importance of clarity. And what I mean with that is clarity of mandate of labor inspectors with regards to recruitment in countries of origin and countries of destination. What I would mean is importance of clarity as to what is prohibited recruitment offenses, importance of clarity of information on problem hotspots in which sectors, including the informal sector that we heard a lot about today, by region and perhaps by workplaces or type of recruiters. Furthermore, importance of clarity in terms of indicators of unfair recruitment that we could possibly use during inspections in the future, and the importance of clarity in terms of sound reporting on inspections in order to enable us all to show that we're making progress towards achieving the Sustainable Development Goals. I think I leave it at that.
Thank you very much, Hans. I see that we still have some comment. I mean, some hand raised. I'm sorry, I won't be able to keep giving the floor to participants, but and particularly in the case of Mr. Landero, if you do have a comment, if you want to share, please don't hesitate to use the chat. We are still online for a couple of minutes. Otherwise, just be sure that we will follow up with you and as other participants as from tomorrow. So we are really looking forward to hearing more from you. Apologies if I cannot again open the floor again, but please, the chat box is still open, if I might say. Maybe Javier, before providing the last words to Maria before officially closing, I don't know if you want to say some words as well from your perspective from the department in charge of labor inspection. Javier, the floor is yours, and in any language you want to intervene.
All right, now I'll follow the language you have been using, so I'll do it in English. So really, I think really, first of all, let me congratulate, of course, the organizers and Maria, for this excellent work and this excellent webinar. I think it has been really very interesting. And of course, the expert, Mr. Hans van der Leen, because I think he has done a very good job, in preparing many of the content of this technical note about this aspect. I mean, this is very important, and it's true that sometimes we receive, how would I say this, some information from different inspectorates saying, okay, yes, inspectors are quite important, but sometimes we feel that we are overcharged. We have to carry out additional tasks. I mean, the question concerning the recruitment of migrant workers or workers is not an additional charge. This should be part, of the regular functions, of the regular tasks, entrusted to labor inspectors. So they have to discharge this, and there are means to do that. And we have heard during this webinar very interesting and very common principles that we try to promote, right? The last participant was mentioning about the cross-border cooperation. I mean, this is essential when we are speaking about, a specific issue that affects several countries, the country of origin and the country of destination of the migrant workers. So the cross-border cooperation is essential for many, many things. And, that cooperation, the minimum content of that cooperation should be the exchange of information. Right? And I think this is essential for the different labor inspection systems to share information with the labor inspectorates in order to be more effective and in order to combat and to tackle this kind of practices that are illegal and that really affects very much, the rights, not only the rights, the lives in some cases, at least the well-being of these workers, which are subject to this illegal recruiting as well. So it's quite important that cross-border cooperation. And then during, the different questions and comments made, they have also raised some basic principles for a labor inspection to be effective, in really tackling this practice. The political will, without that is really difficult. Correct, a clear legal framework, with clear obligations that are not open to different interpretations, dependent, clear obligations for employers, clear rights for workers, and of course, the powers given to inspectors in order for them to be effective. It has been also mentioned several times, the inspection actions to be carried out, concerning this issue has to be announced in all cases. But in many countries, we still have the obligation of labor inspectors to announce the visits before doing, even to get the authorization to carry out the inspection. All these aspects should be analyzed, because it is really difficult for the inspectorate to be effective when really they have such limitations, in the way they carry out their work. I think this exchange has been really quite interesting, and I hope that really it can contribute in the future, really to improve, to reinforce the role of labor inspectors in one issue that is really important, because recruitment is the first step for employment. So if we can really identify the recruitment before that person is included in the labor market, I think we can really protect workers in a better manner. Thank you very much all. It has been really quite interesting. Thank you very much, and good morning, good afternoon, or good evening. Thank you.
Thank you very much, Javier, for your words. And let me then therefore finish with, and give the final words to Maria for officially closing this webinar. Maria, just for your information, there are 187 participants registered to this event. So, and we had a maximum of, I think, 122 participants connected to the event. So I think it's a very good way of clearly exchanging information among different regions and countries. So I think it's very promising. But I give you the floor, Maria.
Thank you very much, Miriam. Indeed, it's very interesting and promising to hear that so many people connected to this meeting, considering that this was not a public meeting, it was a meeting among experts. So I mean, I think we're very happy that it created such an interest. Let me start, before I forget, by thanking everybody who made this possible. Hans, of course, who's written the note and provided content, Miriam, Marion, Melanie, the interpreters that have been translating for us, interpreting for us, and making it possible for all of us to be here and exchange. So thank you very much for organizing or helping us organizing us, and I also wanted to thank you all who connected across, and of course I forgot Olena. Sorry, Olena, I just see you now on the screen, and sorry for that. But thank you all the participants who have participated to this meeting, connecting from very different time difference. So I mean, this has been really useful, I think, and the online version of meetings allow us to exchange, although with all the limitations connected to it. Hans has chosen the word clarity. I think I heard Javier referring to coordination and cooperation. So a lot of words with C. I definitely think coordination, cooperation is critical, and this is also how we, as under the Fair Recruitment Initiative, have worked on this knowledge hub, which many of you have been registered into because you expressed an interest to participating into this. So as perhaps, looking at follow-up actions, we will follow up. We have been very ambitious on what we wanted to achieve in 1.5 hours. Of course, we haven't managed to achieve everything in terms of, running questions to participants through a poll. We will do it after this meeting. We will use the Knowledge Hub also. You will receive an email with questions for you to help us identify what are your needs, what are the topics that you would want to see reflected in our materials. Hans and colleagues will work on training materials. So it is very important that we bring it into practical operational tools and that you take this as an opportunity to contribute to that. So cooperation is also exchanging among each other. So I hope that this group that was here today will continue engage among each other to share experiences, because we have discussed challenges, but also a lot of very interesting practical approaches to address those challenges. And I think if a message had to come through today is that yes, there are challenges, but there are also solutions to those challenges. And we can explore them together, and we need to hear from you in terms of what works on the ground. So I again thank you all very much. Encourage you to visit the Knowledge Hub. It's fairrecruitmentknowledgehub.org, and continue engaging with us in promoting exchange. Thank you.
Gracias. Hasta luego.
Muchas gracias. Buen día a todo el mundo.
Adiós,
Merci
Oscar.
beaucoup.
Bye,
Merci
bye,
à tout le monde.
Take care.
Muchas gracias. Muy interesante.
Bye, everyone.
Wow.